Okay, time being 6:33, I call the Halifax Planning Board into session. All members present except for Collis. And on the agenda, we have 6:30 Autumn Lane, Don Triani. 6:40, we have Scott Burgess, Hilda Lane. 6:45, we have a public hearing, site plan, modification for Mandurah Estates. 7 o'clock, we have Pasture Lane, Adam Murray. Then we have a discussion for zoning bylaws and the typical issues for minutes or paying the bills. So, do I have a motion to accept the agenda as read?
Make a motion to accept the agenda as read.
All in favor?
Aye.
Aye. Okay.
Second first.
Yeah, I'll
Take a
second that. Yeah. I second that.
Okay. So Don Triani is not gonna make it in tonight.
I was gonna ask.
So Scott?
Yep.
Thank you.
My name's Scott Burgess. I'm from Randolph. I bought a 22-acre parcel of Hilda Lane, and I'm looking to put a single-family home on it and move my family there and retire. So I got some plans drawn up, and guess you get that stuff.
Is this just the regular version?
Regular copies,
Yeah.
yeah.
I don't know if we want to dirty that right away. So that's passing it around.
All right.
Sorry, Gordon.
Now, is there already an approved plan for a road
Well,
out there? I'm not
there's been
sure.
a number of things, from what I gather, approved on this, 3 or 4 different subdivision type things.
This is the tentative plan that was approved.
From what I gather, yes.
So yours is lot 3, or no, lot 1.
Well, they're calling it Lot 1 on this, on the new one, and what it would be over here.
Just looking at.
Is that 157.29 feet?
So you currently only own, or do you own any
I
of?
bought the 22 acres, yes.
Okay, so you own the entire piece.
That's correct.
I'd like to have it go through us first too. Like
Yeah.
have us be CC'd on anything that is sent to any land council to make sure that.
Again, I can send everything
the
to
lines
you
are
and
not
you can
blurred.
forward it on.
If you
or
could,
we
yeah,
can send it
I
directly
think it
to
would
Ms.
help.
Wessel,
Yep.
with whom I've worked with
Yep.
for years, whatever's easier for the board.
And I'll take on as much information on this as I can. Including the road. Which is labeled as private?
Is it?
From pretty much from here up is what I understand. That's what I own.
So basically, here.
Yeah, wherever this, yes, yep, and it follows this
And
stream,
then-
yep,
And basically, or are you carrying over any?
yep, up over this way.
Okay.
You didn't purchase the roadway?
That's what I don't understand either.
I'm gonna be real honest with you, I don't think so. I mean, if I need to put the subdivision in, this, I guess.
Yeah, I believe the intent was
No.
always to build a road.
Is there no road at the moment?
Yeah, the road's not built.
No, it's just a dirt
Dirt path.
stone dust path, yeah. That they access now for this house and
this house.
Yeah.
It doesn't say on your deed anything about owning any part of that or anything? Do you have a copy of that with you?
I don't have a copy of that, unfortunately.
So this was never accepted as a
This
town
one-
road.
No,
Oh, it does say.
no, it was
Yeah,
approved
this
as a definitive subdivision.
What year was it?
But the concern I have right off the bat is it looks like you're trying to get onto this lot without ever constructing this road.
Right, I just wanna pull the driveway off the end here.
Yeah,
And going up.
I don't see how that's possible at all.
Were you familiar with the subdivision plan?
That, no, there was another one drawn similar to this that showed 6 lots, 7 lots on it. And like I said, I just wanna go to one.
Yeah, I'd say we'd have to figure out who owns this and who would be responsible to build this road before you actually had access to that lot.
Okay.
Yeah, unless you owned it, which is probably.
And even if he owns it, I'd say he still had to build the road.
I know this house exists,
Yep.
That's
and then
correct,
that's off of South.
right.
Yeah, so
And that
these,
house
So-
exists.
Oh, right off, but is that, all right, yep, frontage off that.
yeah, that's, I'd say that road has to be built.
I wonder if that's why the car was owned to you, not knowing that you had to finish the road off.
Why didn't they build the road
Because
then?
what I'm saying is it looks like you don't own this. It's not like
Right.
you own this lot and
That's
out to the
correct.
road.
Right,
I don't see how you even have frontage without the road being constructed.
according to land planning, they say I have frontage on this road. They went through the checklist and they said everything met your criterias. According to them, they went through all the rules and regs. And they said it was possible.
But the road's never been constructed.
Based off of what I see,
Right.
I don't see that.
So technically, if he owns the road, because the land is technically his, then does he actually?
Well, yeah,
Wouldn't that
'cause
turn around be just his
I mean,
driveway?
you got
Right.
lots built off of this.
Yeah.
How did that occur?
Yeah, that would be my concern is who owns this and who would be responsible for building the road.
Let's just say hypothetically, I do own this coming in. This, I wouldn't be able to gain frontage off of this to get, put my single home in, like they put their houses in.
Well, if there was a road and it laid out like this, then you'd have plenty of frontage to
Right.
build a house, but if this isn't a road, you don't have frontage.
Okay. So how they get frontage, and how they get frontage.
Off
You
of,
know,
I don't know, but I would assume that this was all supposed to be off of one piece.
Right.
I think we do have somebody in the room that has a
I
little
just was
background
gonna
of
say,
that.
I'm looking at this name and I'm like,
Joe Webby, Webby Engineering.
Hey, how you doing?
Hi, good, how you doing? A little history here, I didn't expect this to be, over here obviously for something else. My dad's house was here. My son Brian now lives in that house. At that time, Dad was there on a retreat lot. He had the 50 feet of frontage from Haywood Street, built his house. The Nezarella girls, they built their house with their frontage on Haywood Street. Walter Graney came to my dad, I want to say back in the 08, 07, 06 or whenever, the subdivision. And they made a deal where my dad sold him his interest in Hilda Ave for a lot. And then agreements were made that he would get this lot once the road was constructed. There was a couple of other agreements made that, you know, they would bring water down for Brian, and I believe that pave his driveway, but something like that. And as far as, my son Brian lives here, This Ask Realty Trust is my siblings and myself. And it's always been our understanding with Mr. Graney that this subdivision's gonna be built. And so then we would have a lot. So it's in our interest that Hilda Lane gets built. And it's, as far as we know, it's still an approved subdivision. And at that time, the planning board did grant us the, under a Form A application, the land swap. So our frontage now is on Hilda Lane, but it's not constructed.
So before you can construct a house in there, then Hilda Lane has to be constructed.
Okay. That means I have to go for more lots in order to get the money to build the thing. But I can't just do it for one lot to appease everybody, you know what it is?
Well, you're already
Oh,
approved.
okay, yeah, I think you already are approved. If
I
if
thought
you
there was
have
6
this,
total.
then, yeah, so you can see the former lot lines
Right.
here. So that means it was already designed to function as more than one lot. So
Okay.
that, at least, I mean, that's a definite option, and definitely something you should explore.
Okay, because we'd need to be able to build those in order to get the money to build the road.
That
You know
makes
what I mean?
sense, yeah.
So. All right. So but this one only, I think, only shows 4 lots, if I'm,
I think there's more.
is there more?
Yeah, 4 is what I see.
Here, yours is former lot 3,
One of them is counting,
lot
lot-
2.
one of them is counting this lot that you've got. Yeah, this one here.
Yeah, and that one.
Yeah, that's
I'll throw this in,
considered
you
lot
can choose
1.
it some more if you want.
Okay.
Well, actually, this is the wrong one. They didn't give me the right one. This basically shows what I wanted to do. There's another plan that has, I think, 6 or 7 lots on it. And I just wanted to get rid of those and just have my lot. But that doesn't make it feasible to do that.
No, I'm not
Right.
sure as far as financially how this all works out, but I mean, especially this piece right here looks developable. I mean, you could probably have this.
Should be at
and
least
you-
5
well, I'm
lots that
just-
are developable.
Yeah, well, I was just like thinking, I mean, you could have this and you would never even see it from your house, is kind of what I was gonna
Yeah.
get at. If you were looking for a piece out back, that's still doable.
I mean, a subdivision, what's a subdivision? $500 a foot now, roughly?
Close.
Yeah. You know? Okay. Well, back to the drawing board, literally.
Yeah. Well, I mean, you know, this plan is approved, so.
Okay. All right.
This one.
No.
Oh,
That's-
that
yes,
one.
just-
Yeah,
It's
that one.
definitive.
Right.
The one underneath.
Now, you can think that he had modified that somewhat to build multifamilies. And then he got a special permit for multifamily. I don't know what that probably has a time constraints, but the subdivision is still, in my mind, in my opinion, is still good because it's,
The subdivision is.
yeah, the subdivision is still good because it's been mortgaged in good faith.
Okay. All right, I'll have to get a copy of that eventually, so I'll give you, so you can go get a copy. Yes.
Okay.
All righty. Thank you very much. All right, guys, take care.
Thank you. Look,
Yeah. Glasses, all set. You have Webby engineering?
Yes, sir.
I'll be in touch.
Okay.
Thank you very much.
Have a nice night.
Thank you.
Okay, next up, we have public hearing for site plan modification for Mandurah Estates. We need to have a motion to open the hearing.
I'll make a motion to open the hearing for the Party Trust Amanda Estate, Elm Street, Halifax.
Is there a second?
Second.
All in favor?
Alright,
Aye.
Okay, I'm gonna recuse myself from this, as my son is the abutter to it, so
Okay.
take over.
Might as well slide in on so that I can see what's gonna happen.
I'll leave this here. Let's see. Okay.
let me see.
It might have been in his stuff.
Yeah, see, home was going like crazy, I couldn't see it. Yeah, it is.
The Halifax Planning Board will hold a public hearing on September 5th, 2019 at 6:45 PM in Meeting Room 1, second floor of the Town Hall, 499 Plymouth Street, Halifax, Mass, on the application submitted by Adam Brodsky of Drohan and Toccio and Morgan PC, Hingham, Mass, representing the party trust to consider the modification of site plan approval of Amanda Estates approved on September 18th, 2014. Request to waive the requirement of section 167-7D2A of said property owned by the party trust as shown on Assessors Map 15, Lot 6 and 13, Map 14, Lot 9. The applicant seeks approval for a site plan modification and waiver in accordance with the zoning bylaw of the town of Halifax under section 167-28G4B, Schedule of Uses page 16774, area zoned agricultural residential. Okay, open up the hearing.
Good evening, everyone. My name is Adam Brodsky, and I represent the party trust in this matter. Amanda Monty and Ed Johnson, who are trustees of the party trust, are here, as well as Joe Webby, our project engineer. The underlying facts regarding this matter are a bit complicated. I'll do my best to explain them. I think the issue before the planning board actually is fairly straightforward. I'll do my best to explain the circumstances. You're likely familiar with the Amanda Estates project. It's a 12-unit multifamily development that was approved in 2014 and 2015. The road and infrastructure are installed, and there are 4 units constructed. It's located off of Elm Street, and as Mr. Andrews, the chair, mentioned, his son, Gordon C. Andrews, lives next door at 244 Elm Street. 6 duplex units for a total of 12 units, which meets the requirements under your multifamily bylaw of 1 unit per acre. The project is served by a private way named Amanda's Way, which, as I mentioned, has been constructed. Each of the units is sited on the property to comply with the yard setbacks that are set forth in the multifamily development bylaw at 167-12A5. The project is designed and actually is constructed as a condominium, with a condominium association owning the common area parcel, the land, and with the intention of conveying out individual units to unit owners. The condominium documents were reviewed and approved by the town prior to the issuance of the building permits for the units. As I mentioned, the planning board granted site plan approval on August 18th, 2014, and we're here simply to modify and eliminate one condition in that site plan approval. The project was granted a special permit from the Zoning Board of Appeals in January of 2015. The special permit incorporates the conditions of site plan approval, but we're not seeking to change the special permit. We're seeking to eliminate a condition of site plan approval. When those permits were issued in 2014-15, they were not appealed. In reliance upon the permits, Party Trust built the road and put in the infrastructure. It took some time for the condominium documents to go through the town review process. So the building permits for the 4 units which were constructed weren't issued until May of 2017. And shortly after the issuance of the building permits, Mr. Andrews, Gordon C. Andrews, Mr. Andrews' son, appealed the building permits to the Zoning Board of Appeals. It was almost 3 years after the original grant of site plan approval. I'll try and cut a long story short. The Zoning Board of Appeals in August of 2017 affirmed the issuance of the building permits, did not find that the grant of the permits violated zoning. Mr. Andrews sued the Zoning Board of Appeals in land court in September of 2017. He actually did not join the party trust in that lawsuit. We are an indispensable party. Ultimately, we were joined in that case and became a party to the case. The land court, upon reviewing the ZBA's decision denying Mr. Andrews' appeal the building permits, land court felt that it did not have sufficient information for the court to rule on it. So the land court remanded that matter back to the ZBA in July of 2018. In August of 2018, August 14th, the Zoning Board of Appeals again affirmed its decision. And then the parties moved for summary judgment. There were 2 principal issues that were raised in connection with the appeal. The first was there was an argument that the general provisions of the zoning bylaw under 16710B superseded the specific multifamily development requirements under 16712A. Mr. Andrews lost on that issue. The town and party trust prevailed. So the specific provisions of 16712A govern the matter, govern the project. The practical effect of that is that there are, for example, no frontage requirements for multifamily developments in section 12. Mr. Andrews was arguing that there were frontage requirements as a result of section 10. The land court has said no, section 12 governs and supersedes any of the general requirements. And so, for example, there are no frontage requirements. We need to comply with the other dimensional requirements within the multifamily bylaw in section 12. And as I mentioned, each of the units has the requisite distance between units and setbacks. The second issue that Mr. Andrews argued was that the site plan approval and the special permit required the subdivision of the larger parcel such that each of the individual units was on its own lot. The land court did not render summary judgment on it, said, listen, there are material issues of fact, I can't rule on this, and reserve the issue for trial. It's not going to come as a surprise that the party trust maintains and continues to maintain that that was not a requirement of either site plan approval or the special permit, and in fact defeats the entire purpose of having a multifamily development, because if you actually have to put each individual building on a separate lot, that's effectively a subdivision that could be approved under subdivision control, and avoids and obviates the need to have a special multifamily bylaw, which was to encourage multifamily development, not subdivisions. And I should note that, as you can appreciate, and the multifamily bylaw specifically refers to condominiums. It was intended that these are going to be condominiums. You can imagine the difficulty trying to convey out individual units on individual lots. It's not done with condominiums. Typically, as I mentioned, you have a condominium association that owns the property, that's responsible for maintenance of the property, and then you buy an individual unit and you pay common area maintenance charges, things of that sort. So the notion that you then have to break a larger parcel into smaller parcels complicates the condominium form of ownership, and I don't think was intended by the bylaw. We had a trial in May, and the land court ruled in Mr. Gordon's favor, although the land court said that the site plan approval for the moment, and that's a critical quote from the judge's decision, require the party trust to create individual lots. Importantly, the land court didn't order the removal of the buildings or the road. The land court invited us to go through some zoning process to fix this problem, because it is a problem that can be fixed. Just as a side note, regarding the special permit, the land court held that the special permit itself did not require the division of the lots, but since it incorporated the site plan approval, it's somewhat separate and distinct. So in order to fix this problem, we think that there's a straightforward path to do that, which is to modify the site plan approval. This is not unprecedented, because in fact, that's exactly what this board did in 2016. So at the same time that this board was reviewing Amanda's estates, it was also reviewing a multifamily development, Halifax Trails at 265 Monpont Street, and in fact granted approval for that project in 2014 under very similar conditions. The permits for that project expired, and the subsequent developer of that parcel had to reapply for permits in 2016. And so this is sort of after Amanda's Estates was permitted, after all of these discussions regarding the bylaws and how they apply to multifamily developments and whatnot. But the same issue arose, which is that Halifax Trails attorney said, no, you can't do a multifamily development by dividing the property. It's just entirely inconsistent with the purpose of the bylaw and inconsistent with condominium ownership. And so, and again, I can only glean this from reading the minutes, and I provided you with a copy of the site plan approval modification for Halifax Trails, as well as the minutes from the meetings associated with that. That's attached to my August 12th letter. They consulted with the planning board, they consulted with the building inspector, and they said that the solution to this confusion in the bylaw was to waive the requirement that you have each building on a separate lot. And that's what the planning board did. The planning board determined that it has the ability to waive that requirement under actually the site plan approval requirements at 167.28. There are actually two provisions that speak to the ability of the planning board to waive this. And on March 7, 2016, the planning board granted Halifax Trail its waiver of the requirement that each building be located on a separate lot. As I said, I attached to my letter a copy of the minutes, and you'll see that the board, I think Mr. Millis may have been on the board. In fact, I think you made the motion.
I believe so.
It was a motion that was carried unanimously. The board came to the conclusion, including, I believe, the chair at that time, Mr. Andrews, that it made no sense to divide the property into multiple lots. That would, in the phrase was, it wipes out multifamily and makes it difficult to convey the units out. And so we're asking this board to simply do what it did in 2016 for Halifax Trails. Again, we view, and I think the court views your site plan approval for Amanda's Estates to have this condition, and we're asking the board simply to eliminate this condition. It's like any other site plan approval condition, whether it's a requirement having to do with lighting or shrubbery or whatnot. It's a condition that can be waived. We're not asking for any variance or zoning relief. We don't need any variances, but we're not asking that. We're simply asking the board to eliminate that requirement in its site plan review that we show each of the buildings on a separate lot. I think that's in essence, there's a lot more information, but I'm trying to present this as simply as I can to the board. So Joe is obviously here, available to answer any questions. Ed and Amanda are here to answer any questions. I'm happy to answer. So we're asking this board to waive the condition identically to what was done in 2016 for Halifax Trails.
I believe at that time with the trails and with this, we were all trying to feel the way out first time, all of us going through this. As far as the lot lines, I think there was always a question of whether or not they had to be there.
Excuse me, may I be heard on behalf of Mr. Andrews, the abutter?
Certainly, we're gonna have a little back and forth.
Okay, sure.
So at the time, I think there was some question of whether or not they were required. And I know that we have waived them in the past. So we're gonna take some comments from everyone, but I think it seems straightforward as far as that's the only issue. The question I have is gonna be with the court. I just wanna take a second to read that too, because it sounds like they had no problem with what we did, and there was no issue with the planning board itself. And I just wanna make sure that
Correct.
that
There
is
were-
correct.
As I said, there were just, the issues for trial were whether the site plan approval and the special permit required that Amanda's estate show each building on a separate lot. That was the issue for trial. So there was no criticism of the court of anything that the planning board did. We had already reached essentially the zoning issues on summary judgment, so it was a very narrow decision.
Do we have a copy of the site plan that was approved with conditions from, what was it, 2016, you
okay.
said?
Which, the Halifax Trails?
No, yours.
Oh, 2014?
So I have a copy of that, yeah.
This is from 2000, oh, I see. I was just making sure that I saw the right one. Okay,
Yep.
all right, I got it.
Right, I believe we provided you with copies in my letter. Yes, so the site plan approval for Amanda's Estates was Exhibit A to my letter, and the endorsed site plans for Amanda's Estate is Exhibit B to my letter. Exhibit C is the Halifax Trails site plan approval, and Exhibit D were the minutes of the planning board's meeting on March 3, 2016, when the planning board granted Halifax Trails the waiver that we're seeking in this instance. So you should have all of that. Those were exhibits to my August 12th letter.
Is there supposed to be an Exhibit B? I have Exhibit B and it goes right to C.
I think B was that
That.
plan was removed.
All right, just,
Right, so, and I'm happy to give you my copy if that's helpful to you.
I just want to make sure I have all the information.
Correct. So Exhibit A is the September 22, 2014 site plan approval for Amanda's Estates, and attached to that was the first page of a plan set. Exhibit B is a full copy of the plan set that was endorsed by the planning board for site plan approval in 2014. And as I said, Exhibit C is a copy of the planning board site plan approval modification waiver for Halifax Trail on March 7, 2016. And then attached as Exhibit D are the planning board minutes from March 3, 2016.
And I am to understand that there are no changes to this plan other than the removal of the lines?
That's correct. And the request for the two waivers,
Okay,
correct, which are
okay.
noted on the plan.
Okay, at this time, I'd like to take any comments from anyone else?
Thank you. My name is Ginny Kramer. I'm counsel for Gordon Andrews in a butter. I'm a land use attorney, and I serve as town council for the town of Grafton, which I've done for 13 years. Under state law, site plan approval is a creature of local bylaw or ordinance. It's not contained in the general laws, chapter 48. So the entirety of your authority for site plan approval is set forth in your zoning bylaw itself, and that section is section 28. And that is the limits of this board's authority under site plan approval. The provisions the applicant is relying upon for his request for a waiver is section 28G4B. And that provision only allows this board to waive specific requirements of the information an applicant is required to submit. So if you turn to that section of your zoning bylaw, section 28 states that no permit shall be granted for any multifamily dwelling, and no structure shall be constructed or changed, and no use shall be expanded or established, except in conformity with the site plan bearing an endorsement by the planning board. Then it says the planning board may waive or substantially reduce the site plan submission requirements for projects having limited or minor impacts. G states, the subsection G states that the site plan requirements are as follows. And number 4 is the listing of required information, and then it says waivers. So section A is a listing of the 15 required information that has to be submitted by an applicant, and subsection B states that the planning board may waive specific requirements when they're inappropriate to a given proposal. So that section only gives you the authority to waive what is required to be submitted by an applicant under your bylaw. It does not give this board the authority to waive a substantive provision of the zoning bylaw. In fact, a waiver of a substantive provision of the zoning bylaw, in this, the one building per lot requirement in section 7, the only way to waive that is for the ZBA to grant a variance. And that is not something that they have requested, although they did represent to this board back when they were getting their site plan approval that they were going to seek frontage waivers. Frontage variances, I'm sorry. They also represented to this board that they were going to subdivide the property. In fact, when this proposal originally came before this board, a plan exactly like this was submitted. And when that happened, the town administrator, after consultation with land use council, issued an opinion to you, and there's several copies of it, stating that this plan was not viable because it violated the one building per lot requirement. This was an exhibit that was admitted to the court during the trial. After the Mr. Seelig authored this memo to the ZBA and the planning board stating that the application submitted, which looks like the one in front of you today, could not be given site plan approval because there were not individual lots as required by the zoning bylaw. that is when the applicant had its engineer, Mr. Webby, revise the plans and then presented to you a plan that showed lot lines. And the applicant believed, and the court found, that the applicant could convince the zoning board, after it had its site plan approval in hand with the subdivision, that it could convince the ZBA that Section 7 didn't really mean what Section 7 said and what Land Use Council said. Although the applicant believed that, and that's what the court found based on the testimony of Mr. Webby and Ms. Monty, among others, the applicant never did actually assert to the ZBA that it wasn't required to subdivide the lots. In fact, it submitted the same plan that showed lot lines, and they're called lots, and they are lot lines, and it's not ambiguous. So both the special permit and the site plan approval required the subdivision of lots. After it had its special permit and its site plan approval in hand, the applicant then caused its engineer to revise the plans again while removing the lot lines, replacing them with dotted lines, and calling what were depicted as lots phases. It appears that those plans were the ones, well, we don't know for sure, it appears that those plans are the ones that were submitted in connection with the building permit applications, as opposed to the approved site plan and special permit plans. The building inspector, on the very last day of the 6-month period, issued the building permits, and when Mr. Andrews brought to the attention of the building inspector the fact that the individual lots had not been created, the building inspector told him he could appeal it to the ZBA, which he did. The ZBA at that time changed its interpretation of Section 7, which is contrary to the opinion of Land Use Council Huxham and KP Council, which I also have an opinion for them that I can give to you. That Section 7 requires exactly what it says, that each building in a multifamily development has to be located on its own lot with adequate frontage. So at that time, the ZBA had, for whatever reason, changed its mind and denied Mr. Andrews' appeals. After 2 years of expensive litigation, the court held what was phase 1 of the trial, and phase 1 was only about whether or not the special permit and the site plan approval required the creation of individual lots. The court held that they both did. There's a phase 2 of the trial, which is coming up at some point in the future, regarding Mr. Andrews' claim of bad faith against the town and the ZBA, and now the party trust, based on the evidence that was submitted at trial in this matter. So that the judge, for whatever reason, decided to bifurcate the issue, and so Mr. Andrews is having to go through 2 trials on this issue. With respect to the Halifax Trails matter, in 2016, this board did issue a decision that purported to waive the 1 building per lot requirement of Section 7. However, that decision was in excess of this board's authority. As I've stated, Section 28 doesn't give you the authority to waive. It's not like waiving the placement of a tree. This is the waiver of a substantive provision of a bylaw, not a condition of your site plan approval. The Halifax Trails developer actually made that request to this board after the building inspector directed him to do so. Now, the building inspector, as you may know, has a piece of property that would benefit from an interpretation of the zoning bylaw that did not apply Section 7D to multifamily developments. In other words, he has a multifamily property, my understanding is, that cannot be subdivided and therefore is arguably in violation of Section 7 of the zoning bylaw. In petition 808, filed by the building inspector to the ZBA, he admitted through his engineer that, Yeah,
I'm sorry, we heard about Man's Estates, we're not here about the building inspector. I'm sorry.
That a variance would be required to quote-unquote waive Section 7, because that's what he was seeking, a variance from the ZBA If you want one of those, I have that. So the building inspector urged the developer of Halifax Trail to request a waiver from this board, even though the building inspector has admitted through his engineer that it is only the ZBA that can issue such a waiver, because a waiver of that is a variance. Additionally, there's absolutely no problem, as the judge in this very case found and put in his written decision, with multifamily developments being a condo. All that the developer needs to do is have the condo association own all of the lots as common condominium land, and then just simply deed out the individual units. That has been done, it's done all the time. So the conundrum that Mr. Brodsky finds himself in is not, based in reality. So the problem here is that the applicant represented to this board that it was going to create individual lots, and it was going to seek frontage variances because it didn't have the required frontage for each of those lots, and then for whatever reason decided not to do that, and decided to take its approvals and then build something different than this board has approved. So in my opinion, and I have for you copies of what we submitted to the court on this issue, with all of the exhibits demonstrating that it was the building inspector who asked Halifax Trails developer's engineer to submit this request to you back in 2016. And it would be in excess of this board's authority to modify the site plan approval by waiving a substantive provision of the zoning bylaw.
Excuse me.
Thank you.
Rob Petrillo, building inspector. So are you accusing me of something? And are those two properties that you cited, are they similar and like properties?
Which two properties that I cited?
The property that you cited, that I own, and Mandurah Estates, are they similar and like properties?
My understanding is that you have a pre-existing non-conforming property.
It's a pre-existing non-conforming property. Is Mandurah Estates a pre-existing non-conforming property?
It is not.
So they are not like properties, are they?
Excuse me, Mr.
Yep.
Chairman.
Yep.
Could I just suggest that the communication go to you?
Yeah, only except that really clarifies things,
Well,
because I
have
But
a
it
comment
has
on
to,
that.
because that's
Mr.
the way
Chairman,
it's supposed to be
I have a
done.
comment on that.
I'm running it.
There were two petitions filed by Mr. Piccarelli, and as you know, Mr. Milius, Mr. Tom Milius is a business partner with Mr. Piccarelli with that piece of property. So there were two petitions that went before the zoning board. There was petition 808, which was pre-existing non-conforming, and then there was petition 808.
But none
which
of
went-
those,
which
hold on,
went-
none
I'm just
of
trying to-
these are Mandurah Estates. We're doing
But
Mandurah
in
Estates an
808
injustice right
in
now by
808,
going
they
any
asked for
further
the
away from
variance.
this.
They
By
asked
going
for
any,
variance.
that's great. So I think we're gonna stick to this particular piece of property, and I think any of the, I think Mr. Piccarelli was correct that you did kind of insinuate that what he did was in his best interest.
Well-
So, I mean, I think that was kind of blatant.
Well,
So like, I'd like to keep this
Certainly.
about this project.
Right, the reason I brought that up is only because the basis for the request was the 2016 waiver in Halifax Trails. And the genesis of that request was Mr. Piccarelli, which you'll see in the attachments to my court submittal. So that's the only reason that I raised that issue.
I think the only connection between this and the Halifax Trails is the lot lines. And I believe on the Halifax Trails, we decided that the lot lines were to be removed.
But if we are not allowed to do that, then
So, Mr. Chairman,
if,
Wait, hold on.
out of
hold on.
section 28,
I
yeah.
think she may have alluded to that, but we have done that, and that has worked in the past. So I'm not sure that she's correct on that. You gotta understand that.
And
We've
can I-
done that, and it's worked. So I don't know what she's citing, but I have
I'm
full,
gonna read section 28
right?
for myself.
Chair,
See, I think
can
you
address
should,
that.
because we've
Oh,
done
I
this.
read it, but I'm just saying.
Right.
So if I might address that. And I should say, we have no stake in the dispute between Mr. Andrews and Mr. Piccarelli. I believe that the issue regarding Halifax Trails, based upon the documents that I've seen, and including the minutes, said that they had hired a new attorney, and the new attorney had come to different conclusion than prior permitting, and that's what is reflected in the minutes, consistent with our view. But with respect to section 28, I just call your attention to the fact that that section is called site plan requirements. That's the only section that deals with site plan approval. There are two sections within that, the provision that speaks to waivers. The first is in the first paragraph on, it's page 167, 69, which is the one quoted by Ms. Kremer, the planning board may waive or substantially reduce the site plan submission requirements. And then later on in subsection G, B, it says the planning board may waive specific requirements when they are appropriate to give specific requirements. Again, that references the title to the entire section, which is site plan requirements. This board has already determined that it has the legal authority under section 28 to grant the waiver and has done so on at least one, if not more occasions. So I don't think that that's a compelling argument, particularly given the fact that you've decided that. With respect to Ms. Kramer's recitation of the facts, those are the facts presented on Mr. Andrews' best case, many of which were not proven at trial. So there was conflicting testimony about statements with respect to variances and variance requests, and ultimately what Amanda States was seeking. None of that is relevant to the narrow issue in front of you, which is our request that you waive the condition to show that. If indeed, ultimately, there needs to be some further determination by the Zoning Board of Appeals, we'll cross that bridge when necessary. But I respectfully suggest that again, there's no question that the judge decided that the site plan approval required the location of each building on a lot, and then invited us to come and fix that problem, and we're following the judge's instructions. Because if the judge had come to a different conclusion, determined that, oh my goodness, there's a serious zoning violation, he would have ordered the tear down of the property, and that's not what was done.
Which he stated is still possible, that's
Sure.
still possible.
And as far as the
I'd like
bad,
to open up.
Wait a minute, what-
Excuse me, I'd like to open
I
up.
have two
Jonathan.
things. Can we agree here, first of all, I appreciate both sides going over Halifax trails, but honestly, if I really don't wanna hear that again. We've come to the conclusion that they're two properties. We're using one as a comparison on one side, we're using it as another comparison on the other side. We've come to the conclusion that they are not alike. They're not alike. I feel like that was said, 10 minutes ago. So can we agree that we're gonna put aside Halifax trails in our quote unquote decision?
so Mr. Sirocco, I think you misunderstood what Mr. Picciarelli. Mr. Picciarelli was talking about a different project, different than Halifax Trails. He had another project that he was involved with earlier that was substantially different. Halifax Trails is a 26-unit multifamily development that was approved in a similar fashion to this. So it's the best example. And as I said, it was permitted at the same time that Amanda's Estates was permitted, and had similar approvals granted. Their approvals lapsed, and so they had to come back in. And when they came back in, because of now the issue with respect to what does the bylaw say about multifamily developments, they took the position, we don't need to do this, but they worked together with the town to craft a solution, which was the waiver. So I think you're just confused, but the references to Mr. Picciarelli concern something entirely different than Halifax Trails. And so we believe that Halifax Trails is relevant, has some presidential value.
Do we have a site plan for that I can compare? Because I wasn't on the planning board when that was around, so I would need to see
I didn't
that.
include it in my package, but we certainly
But
can get you the
I
plans.
can't tell you whether I think it's like
So-
property at all if I don't have it in front of me.
So aside from that, I guess we can come back to that, but really, I
You
was
know what I mean?
I was
Like, I don't know how
alluding,
much frontage, I don't know anything.
my next statements kind of allude to,
He's on that one, we took a lot.
I wanna get the understanding of what was the process as far as the site plans being granted here in the planning board, and then approved, what site plans were approved by the building inspector, and what site plans were also presented to the zoning board of appeals, and if they all matched up. Because what it sounded like is that there was multiple variances of what we have here in front of us as far as what was presented, even in front of court. So I just wanna get that all cleared up, cause honestly, that part I was a little confused on. So if I can get some clarity on
I'd
that
be
from
happy-
both sides, that'd be
Happy to
great.
speak to that because, again, that was what Mr. Andrews was arguing to the court, and ultimately, if you review the court's decision, he didn't find that. So, when, and Mr. Webby can speak to this, it was Mr. Webby and his colleague, Mr. Katowski. This is one of the first multifamily development projects to be permitted, and there was give and take between the planning board and Mr. Webby and Mr. Katowski. And the issue of lot lines was raised in front of the planning board, and there's a colloquy going back and forth in the minutes as to what's required. There was a faction that said, oh yeah, you need to divide the lots, and then there was another faction that said, well, no, that doesn't make any sense. And so the evidence that we presented at trial, and again, at the end of the day, it doesn't matter because the judge said, well, there's a condition in this permit that you gotta do this, so you gotta do this unless the planning board's gonna change it. But the testimony at trial, Mr. Webby can testify regarding that, was that they were told to show the lots in the plan, not show the lot lines in the plan, not that they needed to divide the property, but because they needed to show that each building was located, there's a density requirement, as you may know. You can only have 1 unit per acre, so it's roughly 1 unit for every 40,000 square feet. And so there was an agreement by Mr. Webby to put those lines on the plan, but it was simply to show the density. That was his testimony at trial. So the site plan approval plan, as well as the plan that was approved by the Zoning Board of Appeals, that is the plan. Later, when they were condoing this, they needed to create phase plans to show the construction sequence for bank landing. And it just so happened that those phase plans were, I believe, included with the building permit application. The building inspector testified, he was here, that he had all of the original site plans from 2014 and 2015 at the time that he issued the building permit. But it just so happens that I believe the building permit applications have copies of the phase plans. And Mr. Andrews was arguing, oh, this was the argument was a bait and switch on behalf. The court didn't find that, and that argument wouldn't prevail.
What did the court find?
The court found that the site plan approval and the special permit required that Amanda Estates show each building on a separate lot. That was the sole issue that was decided by the court. That was the whole purpose of the trial. We respectfully disagree with that, but we're trying to fix the problem at the court's invitation. The court said, gave us the opportunity to come in front of you to fix the problem, because we have a project that's a good project that has been built. We have 4 units that are completed. There's been never any testimony by anyone that somehow that this project is causing any adverse impact to anyone. During the public hearing process, Mr. Andrews had concerns regarding the buffer zone, so the project was redesigned to provide additional buffer zone. But it's not as if that there's argument that the project was going to cause traffic impacts or noise impacts or anything like that. So we have fundamentally we have all of the infrastructure in. We have 4 out of 16 units built, and the question is, what do we do about this? And so what we would like to do about this is to waive that condition so that we can go forward and complete the project as it was designed.
Can I ask you a quick question?
Yes, sir.
Can you please come up in front here? I'd like to show you what I'm seeing in front of me and explain my confusion. Here's what we were presented today.
This is the new plan.
Here's what we're presented today. Are there lot lines on here?
No, that's what we're asking for. This is the plan
Okay.
we're asking for you to approve that waives the lot lines.
Has anybody, the ZBA, the planning board, or the building inspector, have they seen a plan without lot lines before in just one single lot?
So
And was that approved?
No, so when the project was originally submitted in 2014, it was
Yep.
one lot.
Okay.
The planning board told Mr. Webby to show put the lines in the plan, and so the 2014 plan, which you has, shows the line. So what you see here is if you agree to waive the condition, then we take the lines off the plan, and this is the plan.
So you want
that-
us to, so this plan back in whatever year it
No, this is the
was,
new plan, ma'am.
but it was like that? Was
Correct.
that? was
Originally,
the-
yes.
The plan was like that and
Right.
it was denied by the planning board?
No, the
It
planning
was
board.
after Mr. Seelig
Can I
offered
please-
that
Yeah,
Can I please
memo.
answer
Hold on,
the
hold on, hold on.
question? No, ma'am. So the planning board directed Mr. Webby to show the lines in the plan. He put the lines in the plan. You have a copy of that in your package,
Yes,
right here.
right here.
And that was what was approved. So what we're
it was
doing,
never
this is the
denied.
new
It's quite
plan.
different.
It's the
No,
exact
It
same
is lot
plan.
lines.
Yes, ma'am, you're not understanding.
Yeah, so
That, the approved
that's the
plan
difference.
has lot
That's what you
lines.
wanna get rid of?
Yes, we want to get rid of the lot lines. That's the whole purpose of the exercise.
Yeah,
I'm Corey Murray. When I first come in to apply for this, Gordon Andrews said, you have to put the lot lines in. I said, we're only doing condos, we don't need any lot lines. He said, you have to put them in. So Gordon Andrews Jr., which is behind me, he goes, I want, this is what I want the buffer, but instead of
That's because it's required.
spot the sidewalk.
let him keep going, let him keep going.
Instead of having the sidewalk go down this way, we had to bring it down this way and cut over. That's what he asked for at the meetings. He was here with his father, and he was the chairman. Today, he recluses himself, but we put in, this is what was, the lot lines are in here. He goes, this is what I wanted, so we go to before the planning board. They signed it off from here. You guys approved this plan. I'm not being rude, yes.
With lot.
With the lot lines, right, correct.
What about the frontage of this
But
street?
finally,
approved that,
we approved everything. We're only here for the lot lines. We need to take these off so we could sell, it's one complex, like Twin Lakes, I guess is what to say it. Behind Cumberland Farms.
What's the
same
frontage
thing.
on Twin Lakes?
We're not here about that. We're about taking rid of the lot lines here.
There is no frontage requirement.
For a street?
No, that's
multifamily-
incorrect. That's
A
for a
multifamily development
That's
under
incorrect.
section
The
12.
stricter of the law.
That's incorrect.
The stricter of the law is in
We
our
went before the Board of
bylaws.
Appeals.
Sorry?
Everything got approved.
You go to the stricter of the law. We have 110 feet for a street frontage.
So you
And
need
all
to-
the entire-
so, again, I'm gonna
This is
respectfully
private way.
disagree. You need to look at the multifamily bylaw at section 12.
It
as to what
also
the
goes to the
requirements are.
stricter of the law and it obtains all
It
of
does
the.
matter.
Anyway,
Let him
this is
It's a
continue,
decision
please.
by the land court that
Anyway, this is what we approved. This is
I
what we
just
approved
want-
by the planning
I don't
board.
know how the
I have to come
planning
here, I have to come here first to see you guys. I come in this door with Webby and say, okay, this is what we want. You guys made changes to it. This is what you guys said before I go to the zoning board of appeals. Before I go in, that's true. I'm
No, I
speaking the
wasn't
truth.
talking to you.
But I said, this is what we wanted. You guys brought up the frontage, you brought up this. We finally got it approved by you guys, because it was a lot, way before zoning. We went through the zoning for special permit. We went there, actually, I think Terry was on, what, the planning board. She probably can test it if she wants to. But we got approved, she was the secretary at the time. We got approved for this. The problem we're having now is the judge says these lines have to go because this isn't subdivision control. The
No,
Halifax
that's
Trail.
not what the judge said. That's not anywhere close to what the
But all
judge
we
said.
want to do is get rid of the lot lines.
The lines
That's what we're here.
were added in after Mr. Seelig authored that memo,
That's
after
correct.
consultation with town council stating that
Alright.
the bylaw requires the creation of individual lots. The judge said that the applicant is bound by the plans that were approved, which had lot lines on them. That's what the judge
So
said.
if, all right, so my question would be, is whether or not there was any reason to believe that if we remove the lot lines,
Like Halifax Trails.
if we do, if that has anything as far as further permitting. If we approve
Say that
this
again, I'm
plan,
sorry.
if we approve this without that, how does that affect other permitting for you?
So I can answer that question. I don't think it affects any of our other permitting, because the judge was very specific. The special permit doesn't contain the requirement that each building be on a separate lot.
That's not what he said.
That is exactly what he
That's what
said.
he said, he's bound by your
And-
plans and it shows lots.
So
And that was
if I can
attached to the
finish,
special permit.
please, Ms. Kermit. So the judge basically said, the special permit doesn't contain that requirement. That requirement is in the site plan approval, but because the site plan approval is referenced in the special permit, we need to change the condition in the site plan approval to move forward.
So your building permit and your zoning board permit have no requirement of the lot.
Well, it's a requirement of the site plan approval. So what we will need to do is if the board grants the waiver, we're gonna need to go back to the land court and request modification of his judgment. Because what he did is, again, he decided that the building permits need to revoke. We need to rescind that order and get the building permits reinstated, or we're gonna need to apply for new building permits. But this is the first step, so that what we
Yeah,
intend
I'm just
to
trying
do.
to understand the repercussions.
Right, so what we're gonna do is, again, depending upon the decision of the board, if the board decides to waive it, I've gotta go back to the land court judge. It's not like we get a free pass, and ask him to reconsider aspects of his decision, because he's gotta reform his judgment. We do have this bad faith argument it was against the town. I mean, I can't speak for the town. I don't think there's any basis that the zoning board of appeals did anything in bad faith. Mr. Andrews has sort of expanded that argument now to, they never asserted that claim before, that somehow we acted in bad faith. All I can say is that we went forward and permitted the project and built the project in conformance with our permits until such time it was determined that there was an additional requirement. And so we didn't appeal anything.
An additional requirement, what was the additional requirement?
Additional requirement that the judge found that the site plan approval required that you show each building on a separate lot.
I thought you said that the site plan approval from the planning board stated that, so how is that a new thing?
If you actually look at the site plan approval, I would, that doesn't expressly.
It incorporates the plan that
So
shows lot lines.
No, ma'am. So if you look at the site
Yes, it
plan
does.
approval, which is the letter that's attached as Exhibit A to my letter.
There's also a picture, like when we just had somebody in here previous to you guys for a hearing, we looked at the map to make sure everything was all
The
right.
endorsement is
This
on
is-
the
Sounds like
plan.
to me.
This is
Yes,
a key.
the planning board's
These
endorsement.
are developed.
But
For a
I
reason.
respectfully suggest you aren't familiar with the testimony as to how the lot lines got on that plan and what they
The
were
site
intended
plan
to show.
required them?
Excuse me?
The site plan required them. You
No,
just
the-
told me it was
The
something new
planning
you
board
found out at
required that we
court.
show lots on the plan.
This is silliness. I think we should have a motion to vote. Any further,
So-
what do you guys think? I put a motion to vote on this. This is.
You haven't closed the hearing yet.
So we're happy to
Is
answer
there
any
any other
Hold on.
comments from anyone
Yep,
else in the room? Charlie?
I strongly recommend that the planning board seek the advice of land use council. No matter what decision the planning board is going to be on this matter, it will be litigated, given what you've heard tonight. That means that whatever decision you make is going to have to be based on the law that we have, the advice from council. You're going to have to provide full reasoning for the decision you make. Both whoever votes yes and whoever votes no on this request is going to
Okay.
have to provide full reasoning for that and back it up with evidence and testimony and documentation. Decide to go off and make a decision without using land use council. I really can't advise you to do that. I don't know what the repercussions are, but you're going to be, in fact, holding the entire bag yourselves for the decision you make without seeking that advice.
Okay, could I ask, would we have enough time, I'm not sure what our reaction time on this is, would we have time to contact council and,
I believe if, there's either A, there's a time limit, but B, you have the applicant here. If there's an agreement to extend the hearing to a certain date to allow for counsel, I believe that's permissible.
okay. Thank you. If that does, just to throw that option out, is that possible? If we were to ask for counsel, would you be willing to extend the time if it's needed? I don't know what the time
Mark,
things would be on that.
that brown folder,
Yep,
right on the front cover, right on the front cover,
okay.
I believe there's some dates on that.
Yeah. So 30 days we have. Is
All right, so 45 days would be the
2 weeks from now.
So
We have a meeting.
this is site plan approval. It's not subject to the time standards under 40A,
No, it's 45 days for site plan approval,
under your bylaw.
It's 45 days from what date?
from the
The
date
day
of
was
receipt.
received.
Okay, and when was the date of receipt?
8/12.
August 12th.
So that you've got
9/26.
basically
Yeah.
add 15 days, 12
Yeah.
September, you've got another hearing date in between. I believe you have another meeting.
Yeah.
Yeah, we,
9/19.
okay.
28D, it's 45 days, thank you.
And there's reason to believe that we'd have a response from
Oh,
council on
yes,
that, so if we
yes.
just,
Yeah, I would
okay.
recommend that, you know, you
Yep.
have secretary send all the information. I also think, for help for council, is that you work out tonight what questions you want to ask council. In the sense of, I've heard several matters that are disputed here tonight. I think
And we don't have to do that in public hearing, correct?
Well, you're gonna be in public, at some point, you're gonna have to make a decision to close the hearing. I don't know whether that's a good idea to do it tonight. Reason being that, you come back on the 19th, you close the hearing, you can't hear from anybody else.
Okay.
You may want to continue the hearing until the 19th.
Okay, yeah.
You may, for instance, council may be here on the 19th, and that advice from council would be entered into the hearing testimony and documentation. So my recommendation would be to continue the hearing till the 19th, seek the advice of council, but at tonight's meeting, establish the questions that you want to ask council, since obviously there are a number of disputes between parties who are interested here.
Okay. Thank you.
Mr. Chairman, can I ask?
Yep.
If you're gonna open up the site plan, I would request you, if it's all gonna be on one lot, there's a 30-foot buffer around the whole project as it's required. It's a requirement.
So we are not,
So you're opening up the site plan.
we are not opening up the site plan, that's not the request before you. The request is simply to waive that requirement. So we have not requested.
All right, yeah, so I'm gonna have to check up on that, because,
So let's put it on the list of questions.
okay. So that will be on the list of questions.
And we have no
And
problem with
just
the
so you know,
continuance.
that's what we're looking at. I think that the 19th, if we can continue till then, we're still gonna discuss this now, but I believe we're gonna continue to the 19th, and we'll have time to contact council. But one of those questions should be that.
Yes.
All right, so what do you think biggest question for you?
I think, if I may, one question would be whether or not section 28 gives you the authority to waive substantive provisions of the zoning bylaw. And if not, if there's anything else that gives you that authority.
I would modify that saying whether it allows you to modify the site plan requirements, not substantive provisions of the bylaw, because that's a characterization. So the question is, does it give you the authority to waive the requirement per the note on the plan?
Well, the thing is this a variance or a waiver? Because essentially, they're waiving the right to, they're requesting a waiver to get rid of these lot lines. However, it is technically a variance in the sense that the site plan was already approved.
It's not a, again, it's not a variance, but if you want to ask your
Do you know
attorney,
what I'm saying?
it's not a variance.
Yeah,
That's
it's
how I
not
feel about
actually
it.
a
The site plan was approved with lot lines on it.
Yeah, but-
And therefore,
You
the
gotta think of the term of the
variance
variance,
would, the
though.
variance would have to be
The
given by.
waiver
But
needs to
a
be done
modification
before
of a
site
plan is not a
approval.
variance, like, they're not asking for a variance from a certain setback. That's not what they're asking for.
Correct.
But it's still a bylaw, so it needs to have a variance. And where is the hardship? That was the hardship.
Again, I don't think they have to prove hardship, because it's not the variance.
Right, there is no
Before.
variance request,
Charlie,
it's a waiver which we believe you have the legal authority to do of your condition of site plan approval. There's no request for any variances.
Okay,
I'm
Charlie?
not going to disagree with any of the council here, but simply put that on the list of questions.
Yeah, that's
Is
right.
this a-
Yeah,
Is this
that's-
a waiver, is this a
yeah.
variance?
Yeah.
That's what I was trying to get to.
Mr. Chairman?
Yep.
Can you ask council to look at the advertisement for the Halifax trails and see what was done? So she has an understanding, because what was requested in the notification to the public was not what was done by the zoning board. So you're using that as an example?
But, yeah,
You're
I'm
using that
not,
as an example for what
father
took
signed it.
place.
yeah.
You know,
I guess- I
we're not
guess you
challenging
wanna-
any zoning
I guess
issues
the fact is
with
that
respect to
We want to
Halifax
get an
trails.
understanding from our land councils whether or not if Halifax trails, we can get like a baseline of what was done there and kind of compare it in the sense that legally,
Let them see if there's a
let them
connection.
legally to see if
Okay.
there's a connection.
Yeah, I wanna see it myself.
Because we can't legally connecting the dots on our side is,
Well, I'm also of the
I don't
belief, just
agree
because
with
somebody
that.
else does it, doesn't mean that this board decides it. We have our own individuals looking at the laws.
Okay, that's a good point. Now, would anyone happen to know, would our council be the same council that represented the town in this? Like, would they know?
In the court case, no, because
Okay.
we've changed land use council since the court case started.
Okay, just wondering if they would be
The
familiar with
the
it.
Amy Puzzle from Copeland and Creek would be submitting everything to.
Alright, so my biggest concern is if somebody could break down some of the
so this is
judge's
totally,
rulings for the last time. I don't know. Right?
well, they have to be posted, I would assume.
We can provide you with a copy of the.
I
Yeah, but if-
provided the planning
I
board
think
with a
if-
copy last night.
When was it submitted, the copy?
In August.
Yeah.
I'm sorry, was there a planning board meeting concerning this
I got it
matter?
in his mail.
Excuse me?
I'm sorry, was there a planning board meeting concerning this matter in August?
No. I brought it in his mail to give a copy, gave a copy to the zoning board, and I gave a
I
copy to the
haven't
planning
even
board.
read it.
That might be it. Alright, if he brought that in, I might have, I think I have.
We're happy to send you a copy of the judge's findings.
If you could.
In fact, it would be easier to send it to Ms. Wessel directly, or
Is that a conflict of interest?
What?
If you worked with this land use counselor, that is not a conflict of interest at all?
I've worked with
I know
hundreds,
you worked with a
hundreds
lot
of
of
land
lawyers,
use lawyers
but
all the
being,
time.
working with them, beside them, is a whole nother
No,
story.
no, when I say working with her, she's town council, I represent applicants.
I got
So
you.
I've never been co-counsel with Ms. Wessel regarding any matter.
Just don't wanna blur the lines, just trying to stay straight on the path here.
Well, I think that I'm definitely gonna read the judgment and wanna know it.
Yeah, realistic, I mean, we're not gonna make any sort of
We
decision.
we welcome
right
you
now.
looking at all of this information.
Can I just ask a simple question? Why take the lot lines out?
Because
Just
the-
this very simple,
Alright, so-
hold on,
so-
I just wanna
Oh, you wanna ask
get,
him?
just
Okay.
wanna get a
He can
a very,
fill that one.
very quick,
Two
very
reasons.
summarized understanding.
One, we don't believe your bylaw ever intended that you subdivide a multifamily development. Two, I respectfully disagree with Ms. Kremer. I'm the second lawyer that's been in front of you that said there are problems with conveyance if you have a condominium with multiple lots. The first lawyer being Attorney Pellegrini, who represented Halifax Trails. I don't do conveyancing, I have a real estate department in my office. I can assure you that it is a real-world concern and causes difficulties. So
To have lot lines.
Yeah, so that was part of the thing with the Halifax Trails that I recall, is that whether or not they would have trouble with like legal descriptions of it, right? And yeah, so like that was one of the things. So when they first asked and they're like, we're gonna need lot lines and we don't need them, I kept asking, because as far as I'm concerned, they don't really need them, because how are you gonna have a 10-acre parcel with 10 one things? You'd have one huge building with 10 apartments in it, and that's clearly not the intent of the bylaw. So if they don't need it, they don't need the lines for a legal description. I don't think they need them to satisfy me or this board. I think the only reason that they may
What about
have
the
needed,
town of Halifax's bylaws and the fact that we have to represent them?
because the town of
because the
Halifax's
residents-
bylaws aren't really that great. And if
But
you
it's,
start
they're
looking
still the
at them,
bylaws. They're still the
So
bylaws.
I haven't
We
agreed-
represent the
yeah,
residents
and
of
you
the
can
town,
still
and we're
look
not
at
here
two of
to
them and be
change
like,
them.
oh, hey, those conflict. We understand
So-
that that
What are you
happens.
looking
I think the intention, again, I can't speak to this of personal knowledge, but I think the intention was to get the density. You wanted to make sure that you proved that you have one building per acre.
And to that
Not that you
point-
actually have to physically create all of these individual lots, but you wanted to restrict density. You didn't want people to do 24 units on 12 acres. You wanted them to do no more than 12 units on. And so the problem arises at the difficulty of reconciling the different provisions of the bylaw because it is not clear.
But you were okay with it back in 2014 when we signed the
No, sir.
approval.
So.
If I may just say
Can I
that,
finish, please, before being interrupted? And
Just
again,
let them finish, I'll let you hop right in.
Again, and you can hear from Mr. Webby, because he was the one who testified under oath. We came in saying that we don't need the lot lines. The planning board said, put the lines on the plan. The planning board just said, you don't need to subdivide it, but put the lots on the plan, the lines on the plan. And
Yes, that is-
Mr.
that is
Webby,
what happened.
and Mr. Webby agreed, because his job is to permit projects, and he tries to accommodate the board, and that's what happened. And that's why
So
we're.
then why did the judge take away the,
Yeah, if we could.
So can I answer
Excuse me,
this
hold on,
question?
no,
No.
If I understand,
one
if I understand
second.
the question, I'm
Hold
sorry,
on.
I can't answer that question?
Hold
I
on,
was-
hold on.
yeah.
So.
I
so
didn't,
what-
hold on, stop.
Yes.
I didn't even hear your question. So if you could please just ask it again.
why did the judge take away the building permits? Why are you guys here?
Because he said that your site plan approval contained this condition that we show each building a separate lot, and we hadn't done that. So that's why he ordered the revocation of the building permits. At the same time, he said, I'm not gonna order any relief here. He afforded us the opportunity to, in his language is for the moment, and then he just described a couple of different ways that we could try and solve this problem, one of which was seeking modification of the site plan approval. That's why we're in front of you.
So the site plan had lot lines on it, you built it, you got taken to court, and then the judge said that you need lot lines, and now you want us to waive that.
Correct.
Is that, so
Yes,
it's
that's
like
correct.
doing it and then wanting forgiveness?
There was no problem because the building inspector issued,
lot lines.
the building inspector issued the building permits with the lines and the plan. There's never any secret, no one ever appealed the special. If Mr.
If I may-
Andrews didn't, if I can finish please, if Mr. Andrews didn't want the project, what he should have done in 2014 and 2015 is appealed the site plan approval and the special
And
permit.
the reason-
He didn't, he waited
The
3
reason he didn't do
years
that
before
is
taking
because
any action,
it
and in the
required
interim,
lots.
we built the project.
Correct.
Okay,
Out
now,
of conformance with your site plan approval and your special permit. So,
Which is-
Mr. Brodsky's opinion that the zoning bylaw does not really mean in a multifamily development, each building has to be constructed on an individual lot with adequate frontage. His opinion is that you can just read that, you can just ignore that out. That is contrary to the opinion expressed by Mr. Seelig. It is contrary to the opinion expressed by Richard Huxham regarding Amanda's estates. It is contrary to the opinion of your current land use council. Here, I would like to add all of those to the record. And also, I would like to draw your attention to and the judge did not say you could go to the planning board. The judge said you could go back to the zoning board. And if you want me to retain jurisdiction, you have to limit your request for relief to the zoning board, which for whatever reason, they're not doing that either. But I would also like to submit for the record our opposition to the party trust renewed motion to stay, directing your attention to page 4, which is the provision for your council, my opinion, that site plan approval provisions of your zoning bylaw do not give you the authority to waive substantive provisions of the zoning bylaw. And also drawing your attention to Exhibit B, which is the memo by Halifax's Trails Council setting forth the bizarre interactions that led him to ask this board for a waiver of a substantive provision of the zoning bylaw, which was not, as Mr. Brodsky has represented, based on his interpretation that Section 7D can be read out of the bylaw. And I just want to say for the record, without wasting anybody's time, there have been several representations by Mr. Brodsky regarding the court's opinion in this matter that are just contrary to fact.
Sure, and you can read the judge's opinion and make your own determination. I have yet to see that pleading. I wasn't provided with a copy of it.
I served you yesterday.
I don't have a copy of it.
But would you like a copy of it?
It's okay, I'll get it from
We
you
have extra copies, okay.
afterwards. So I just haven't seen what she's handed to you.
Okay.
And by the way, I'm not saying that you ignore the language under 176(7). I'm saying it has to be read in the context of the entire bylaw. We showed that we had the correct density. That's lost in the forest here. Again, if we had built 24 units on 12 acres, that would be a clear violation. We actually built 12 units on 12 acres, which is the density required.
As far as I'm concerned, the density is taken care of by multiple other setbacks.
There's no
Once,
about density.
Why
Excuse
should any property in town, regardless of them being a single family or anything, pay attention to setbacks or lot lines or anything if we waive this?
no, so what I'm saying is.
Why is a multifamily
Listen.
development different, whereas then they don't
Seriously,
have to have certain
So,
setbacks?
because
but
of the
single
type of-
families do?
Because of the type of
That doesn't make
project
sense.
this is, there are tons of setbacks that they already had to meet, right? So what I'm saying is the density is already taken care of by the other setbacks that are imposed on this type of project.
But it's still all under the the law. It says the stricter of the law comes
But
through.
but I'm just saying as far as density,
It says-
density has already been provided for, so that this type of development has the setbacks in it.
But
And
the
it's true.
site plan had lot lines on it, and that was the one that was approved. And the reason that the judge said that it, from what I'm gathering from you guys,
Yeah,
'cause
we
I
do
haven't
not
read
know
the,
what the
I haven't read the
Multifamily
judgment.
anymore, it's in subdivision control. That's, you've allowed.
Yeah, so-
What did the planning
It's not
board say?
multifamily, this is why we wanna take the lines out. Because right now, the judge is trying to say it's subdivision control because the lot lines are in it.
Because
And
that's
if you read the bylaw says,
We
you
believe
know,
the town has to.
multifamily
They're putting
use,
a lot,
that's
we
what it
followed,
says. Read the bylaw.
One person.
That's one
we
thing.
followed the town's.
That's
So
one
we
thing
don't
is
know. We
I've been
came
in
in
with the
here.
project, and I
Yes.
believe so. I think
We
that,
followed your direction.
And what we'll do is, we're gonna also provide the board with a copy of the summary judgment order, because I think you're mistaken with respect to your
Well, I thought that,
interpretation.
I'm just getting it from you right now.
Yes, that's
Remember
what
I
I'm
just
saying, yeah.
asked
So
you?
you keep saying the stricter. So the judge made a specific determination that this project is governed by section 12, not section 10, which I think has the stricter requirements that you're alluding to.
This bylaw, this whole entire book says that bylaw, the stricter of the law, it's for the whole book.
So I'm going to respectfully suggest that the
it's for the
judge has
whole
made a
law.
determination as to which sections of the bylaw apply to this project. And you may be mistaken with regarding your general impression
I'm
of
not.
what governs.
But
Mark, it was, the judge's determination on summary judgment was to give deference to the zoning board's interpretation. He didn't say that's the correct interpretation, he just gave deference to the zoning board's interpretation. So the planning board can have a different interpretation of what the bylaw says.
I disagree.
Yeah. No, I can just read the, I can read it.
that's,
Because
we're
your
gonna have to go
function is not
to con.
interpret the zoning bylaw, your function is to apply the site plan approval criteria. You're not the zoning.
But the zoning
Based on
bylaws
how
are
we
what
interpret
guide
the
us
bylaw.
to approve the site plan.
No, ma'am, it's the site plan
Yes.
approval requirements under section 28, which is your.
When
purview.
we look at site plans, we have to know our bylaws in order to know what we are looking at, to know whether or not we can approve the site plan. We have to know the bylaws.
which is why the board asked for the lot lines to.
I mean, should,
I'm not
otherwise,
disagreeing.
do we
I'm
just
not
say it
disagreeing.
looks pretty?
I'm
It
not-
looks pretty, let's do it?
I'm not disagreeing with respect to, you generally should know the bylaw, but this is a project subject to special permit, so the zoning board of appeals in the special
First
permit process
step, site plan.
determines, whether there's conformance with the provisions of the bylaw as they apply to the project. Your role is advisory for site plan approval, that's how the bylaw is structured.
Based on knowing the bylaws, or else we wouldn't know how to do that.
But it's not your job to rule on which provisions of the bylaw apply to a project, is what I'm saying. That's not the function of the planning board and site plan approval.
Then why are you asking them to waive something?
Because the judge has determined that your site plan approval contains this condition, and we're seeking to remove the condition, because you put it in your site plan approval.
Based off of his interpretation, based off of your interpretation, based off of their interpretation. It's all based off of our interpretation. We get elected based off of our interpretation of our town's bylaws and how the townspeople agree that we interpret those bylaws. So ultimately, I'd like to say that you're incorrect. It is Amy's. If Amy has an interpretation of the bylaw her way, I may have an interpretation of the bylaw my way. That's what makes us a five-person board. So we all interpret everything differently because the way that laws are written leaves open for interpretation.
I'm not.
Do you agree or disagree with that, my
I
statement?
agree with that entirely.
Thank you. That's
But we're
it.
talking about something.
We're done.
So we're talking
done
about
with the
we're
interpretation.
talking about the request that's in front of you and procedurally how it got in front of you, which is a different question. So I'm not going to suggest that the board is not going to have occasion to interpret provisions of the zoning bylaw. I'm just explaining to you how we got here and why there's a.
You had a site
All right.
plan.
Well, I think at this time, unless there's anyone with anything else to say, I don't know that we're necessarily getting any further. I don't want to stop anybody from saying anything they want, but I think at this time, we're
have some
gonna
questions.
contact council and we're going to.
Make a motion for
I'd like-
continuance.
I'd like a motion to continue until September 19th. We'll do the same time, just to keep it.
What time it is at the moment?
No, we need a time on the 19th.
Yeah, that's,
Yeah.
what time, do you know?
6:30 is fine.
6:30? Okay.
Yeah, because we have 7 o'clock starting with the hearings.
So we have to basically reread the.
Just so the board,
Yeah.
see,
What is in motion?
I don't think it's going to be unexpected to you, but I suspect you're going to, if you start at 6:30, you have your zoning bylaw hearing at 7.
Yeah, that's
Probably
what I
gonna have
understand.
to Continue the hearing till later that night. Essentially, you get it from 6:30 to 7, you'll have to
Cut it
Oh.
off at 7.
just cut it, continue it after the hearing, the zoning bylaw hearing. Just in
Okay.
terms of logistics, I suspect you're not going to get this done in 30 minutes.
Gotcha.
Well,
Like
then
a
we can just
start.
continue it
Yeah.
until after the hearings for everything else.
We have to lay that out though, the fact that we wanna do a hard stop or. a
Yeah, I
Because
wonder
how are
if
we
there's-
gonna know when the hearings are gonna end that are already
That's what I
advertised?
mean, how are we gonna keep them
Well, you
from sitting there all
just-
night?
Right now, you just make a motion to continue until 6:30, and then once we get to,
Then we push it again.
we'll push it again.
We can't just make it for 7:30 and
Do you
then,
think you're going to get the hearing done in 30 minutes? I mean, obviously, as
I don't think we're
I'm sure
gonna.
you've got other people here for other things right now. So what happens, I mean, normally,
You're
I
not
think
gonna get the zoning public.
no, but what I was thinking, we're not gonna get it until, say, 8:30, and let them come at 8:30, rather than have them sit here at 6:30 and then sit here for 2 hours, right? Is that better? No?
6:30.
All right, let's get Joe out of here quick, 6:30.
Yeah.
All right, so be
Either
it.
that or have another day, one or the other. Pick a Wednesday or something. Tuesday.
I was just trying to keep it from sitting there the whole time.
So let's keep it
If
for
you
right
wanna
now
push
from.
it to October, then we need an extension.
All right, let's go for no extension. Try for 6:30 and hope that all the bylaw things go quick. All right. Do I have a motion?
No, because you need the paper to read the whole, you need to say that
Yeah.
there's a continuance of the motion that was previously, or the,
Ooh, let me get that for you.
I think Amy wants to read it.
It's a simple motion, just a motion.
I got you, I know, but he has to read out, yeah. Where did you put it?
Oh, we have a lot of paperwork tonight. It's everywhere.
I just had it.
Dude, do I look like I'm good at this?
Are you writing on the back of it?
You should give me the,
It's probably
is
under
it over
there.
like there? Or
No, no.
That's yours.
No. Hey, let me see. I think you're writing on the back of it.
Probably is.
Ah, yeah. You want me to read it?
One of you got, I can't, cause
Yeah.
one of you
You just
have
gotta
to
make
make
a
the
motion for
motion.
continuance.
All right, so I make a motion to continue the notice for public hearing. The Halifax Planning Board will hold a hearing tonight. We're gonna extend it till September 19th at 6:30 PM here, 2019, here, thank you.
Downstairs in the selectmen's room, please, because we'll
Oh,
already
yeah.
That's correct, downstairs in the selectmen's meeting room. The whole thing, gotta read it?
No, just the fact, I don't know what it was.
Okay.
What's that?
I have a motion, do I have a second?
Second.
All those in favor?
Aye.
Thank you very much.
Thank you.
Good night.
Thank you.
So, should we get a copy of this? Or I could scan it and send it to everybody. Both sides. Huh?
What is it?
They didn't take their bylaws.
I don't know yet. My head's like, I did that whole thing with the motion because everybody's standing around me. I was like, all right, enough. I was getting kind of, pack a coyote feeling.
You might
I
have
was
a
like, all right.
The guy was a good down call. Ain't getting any better.
You're gonna get kicked out of your seat. Let me move over.
Are you sure? Do you have your stuff? Do you want your stuff? I'm like, all over the place here.
This is all.
So these are things we need copies of too, apparently.
I got the bills over here, Gordon.
Is mine.
I didn't notice the time.
I'm gonna keep this so that we have it, because I have this organization thing. Is that all right?
Yeah, but my crappy notes are on the back that I'm gonna have to,
Just so it's
I'm gonna have to rewrite that because no one other than me can read that.
I have no idea what that means.
I don't even know if I do.
You want to get some easy stuff out of the way?
I
for us?
actually remember a lot of the questions that I could probably decipher it, I think.
Yeah, I
I'm sorry.
Moving on. We have a bill to pay for advertising. Somebody wanna make a motion?
I make a motion to pay the $84 to the Plimpton Halifax Express for meeting legal ads and Mandurah Estates.
We have a motion, is there a second?
Second.
All in favor?
Aye.
Aye.
Need 2 signatures, 3 signatures. Okay, we need some signatures on a site plan for 450 Industrial Drive. Not sure who was,
That must have been me.
I think I signed.
3 of us? Maybe Collis.
I was here.
Alright. Bills.
you have their names on them?
Am I the only person signing this?
Nope.
No. So other people need to sign this right now? Yeah?
Yeah, so it's gonna have to be.
You don't have
Jonathan
minutes?
Meyer.
Oh, I didn't even see that
No.
part there. I just didn't want to be the top person, that's all.
Now I know what
hate
you
being
mean.
the top person. I don't wanna be the top person.
Does anybody wanna go over the zoning bylaws that we have coming up on the 19th? So what we have is the public
That
hearing
was
for
all gonna
that.
be the same. When he said that, I didn't even think about that's all the same night.
So it's gonna be a late night.
Oh boy.
Well, I mean, I don't know.
There's no
Depends
bad
on how
time to
many
say
show
that the
up.
recorder hasn't been going. No, I'm just kidding.
What did I just miss? is this so I can get you guys copies of all this? Alright. So what are we gonna do, talk about bylaws?
background?
Yeah, it's actually making it so that I can like sit more comfortably.
I was just opening it, is there anybody wanna have any more discussion?
Did you motion to bring yourself back in or not?
Yeah, 8:10. At 8:10 I came back in.
The only thing is I think I lost a piece of paper that I wrote down all this stuff on.
What are you talking about? It's right on the
It's right
No,
here.
no. This thing that we had last week when we went over them, and I
See, you need to get a little binder like this.
You need to be organized.
look how many pieces of paper I have right.
These are the ones that are going in, Mike.
Yeah,
this
so
is
I
the
think we
final
went over
draft.
them last week, and I wrote down how I felt about each one of them, and
Oh,
then
you don't have any notes?
I don't know what I did with that.
Oh, okay.
How do you feel? How does it make you feel?
Yeah, tell us about
Yeah.
that.
So basically, anything in Article 2 at the moment where there's licensed pubs in the area pouring alcohol, they're currently
500?
like anything that is within the 300 feet or 300 foot range right now would be just non-conforming at the moment, but previously approved, right?
On which one?
On Article 2. Unless that's current, I don't think that's currently stated that in the bylaws. 130:12.
These are just the changes, so you have to look at the bylaw to see what it's
Yeah.
coming from.
See, that's why it gets all confusing. I have them.
So the next meeting, we're gonna have the public hearing for the zoning bylaws. That's where we'll have discussion from the general public. And we can either make a determination at that meeting, or we have to make it before the town meeting as to whether we approve or disapprove. Or recommend. Some more paper shuffled around tonight.
I think I almost got down to the bottom of it though. I know what it all is.
Lots of trees.
What is Exhibit C?
I don't know, but that looks pretty official. And I wrote all my stuff on the back of it.
It's an official copy.
Yeah, I wrote it all nice too.
Looks like notepaper to me.
Take a picture of it with your phone.
Well, this is just to give to council. Those are the 4 burning
It's Exhibit
questions.
C. Exhibit C are questions.
Good times.
I mean,
So-
Blankest piece of
I mean,
paper.
you look at it this way, our clerk is the most organized person in the world.
That's so bad.
Maybe after this year, I'll take over.
That's a good idea.
I'm pretty organized.
Demoted.
Or I can give you lessons.
Yeah, it might be a promote. Yeah. I lost that. That's great.
So You're talking 167 on 715, which, sorry, 7D15. Is that what you're talking about there? No? Did you move on? You moved on?
Oh, I'm reading, yeah, so I'm on Article 8 at the moment.
So they added, in that one that you were talking about, it looks like they added,
300 feet
yes, to the
That's what I'm talking about.
agricultural district.
Yeah.
Yeah, that's what I'm talking about, like, so that anything right now
Or,
is pre-existing non-conforming.
Well,
or
it would
any
pretty
parcel
much-
zoned agricultural
It would
residential.
pretty much wipe out most of the places, because if you go 300 feet from the agricultural to the property line, that's what you go to, is the property line.
Right,
So like the business district, it only goes back 200 feet or something, there's agriculture behind it, so that wipes that out, you know?
yeah, I mean, it just basically means it'd be really difficult for any kind of new pub to come in,
For the marijuana.
or marijuana, no, it says or establishment license to pour alcohol, so pub.
Oh yeah, like would it work in the reverse, that you couldn't get a pub near one of those?
Yeah,
I would think so.
that's what the law reads, yeah. So ultimately, there can
I
be
would
no
throw it
more
in check,
pubs
but I won't.
essentially to be added unless you can find a holy grail of a lot
It's a good point.
in the business district.
See, repercussions of our actions.
No, I don't know. If you read that, I think it's the distance the marijuana has to be from that facility,
Yeah, so could you,
from the facility that pours alcohol.
Yes, but if a facility ever did find a place to get in, then there probably couldn't be a pub within 300 feet of that
Oh, it's
by
like-
this
yeah.
change, right? Instead of 5, because it's 500 now, right? Yes.
No, I don't think there's anything to that.
Oh yeah, no, I read it wrong.
Oh, yeah, there's nothing to the
No.
agricultural. I was on the pouring of alcohol, excuse me.
Never mind, read it wrong. It's all good. You're right. The main subject there is the marijuana dispensary or establishment.
But what it's doing is declaring 300 feet from residential agricultural,
Mm-hmm.
you can't have it.
In any pub. So,
He's just playing cards.
I wish. Can't do this when I'm driving, so.
You gotta get a different app.
Well, I gotta get it 10 years from now, then I could do it in the car while the car drives.
Right.
You could get the app where you think you're home.
There's an app, probably there is, huh?
there's an app for that.
Okay.
I don't like Article 10. It's a long one.
Oh,
Oh, there's our density regulations again. That's the two. That's something else I didn't see in, I wasn't sure, but when the site plan was previously approved, was there, any kind of fire suppression system in the building? Was that going building
That's definitely
CBA?
fire, like that's not us, but like I don't know.
But that's one of the requirements.
But I think that's usually if it's a square footage thing.
No, it says every multifamily development, whether condominium or rental.
Okay, alright, so I'm not on the same thing you are, but that makes sense.
Yeah, I'm on
If
the
it's-
side,
if it's-
8A.
So if it is multifamily, then
Or
maybe
condo.
that could be.
Yeah. Just popped up in my brain when I passed by it, but whatever. I didn't see anything on
Yeah, I guess we can have the. Yeah, I don't think that falls under this.
Yes.
Wasn't it, when we were talking about some site plans to add in the, like the pitch of the, entranceways and stuff like that, cause I know it was brought up when we were doing Dunkin' Donuts.
Alright, so what we ended up doing, I don't know if you
It was
ever
like,
got
oh,
the
we
plates.
should have this.
I think these things kind of took care of it. Let's see if there is one specifically, so. That's
Yeah.
That's the berm.
Oh, yeah. Do you remember, I think we were talking about that, or, cause that was how do you,
A little steep.
yeah. Never really came across that before. The
As
only
far as,
time we
as far
talked
as I know,
about
yeah,
is
like, I mean,
that, gentleman's driveway.
I don't know that, I think that's really what happened, is we've never had a specific regulation, because none was ever necessary. You know, it was always, they just put a driveway in.
No, it didn't come from that, it came from Dunkin' Donuts.
We had one where the guy didn't like the transition from the road onto his driveway. And there was some funky stuff where like the guy had paved it before, and then like before the road was done, and then when they brought in the road, it didn't meet up and like things like that. It was really weird, but we were out there discussing like 5 feet of pavement that's like, it was like tough to figure out, because the guy was saying it was too much of a bump, but we don't have anything to really say how big of a bump can there be, and like, you know, how much of an issue is it? Because obviously every time you go over a driveway, you feel it, you know what I mean? So it was tough to say, is this guy overreacting? And we didn't have like a number or a formula to say, or a measurement to be like, yeah, this is right or this is wrong.
Right.
We could just say like, the guy's not happy, like, can you make him happy? And that was all we could really do. So if we had something, we were just thinking if we had something to point at and say, hey, it's not this good, but you're always gonna have a different transition from the roadway. I mean, typically you'd want straight with a slight incline up to keep the road water in the road and keep it off of the driveway and vice versa, but.
We also gotta follow sidewalk laws too, a lot of the subdivision, or like all the multifamily developments.
If you have sidewalk,
you can't have that
transition's
pitch, yeah.
gonna be different,
Yeah.
so it's tough to,
It's
like,
tough.
it's tough to draw a picture and say all driveways should look like this, you know what I mean?
Yeah.
But O'Reilly's didn't do that either, did they? They didn't describe the picture of, but do you know what I'm saying, like, it's come up like, it's now come up a few times.
It's come
But
up
I don't
because
know
of the
how to
Dunkin' thing.
determine.
I don't know if you've ever been in there, but like you can see it when you drive by, where it's like, I don't know, it comes like right off of the road, and I don't think any of us envisioned that. So that was the question too. It's like, all right, like how do we keep that? Yeah. So when you go by, you'll notice it's pretty harsh, like transition, like from the road. I don't go in it, so I don't know what it's like to drive, but you can see it.
I didn't think they meant to be at that high either, but that's a whole nother story for another
Yeah, like
day.
there might have been construction reasons why they had to keep it up.
Septic system.
Yeah.
Oh, yeah, that's right, sorry, yeah.
Yeah, but I mean, like they might even, the septic might ended up
Sorry.
8
I don't think
inches
they
high, or you know what I mean. There could have been.
It's the water table, yeah.
That's what I mean. It might have ended up higher than they thought,
Yeah.
and then now you got more of a slope.
Doesn't stop people from getting their donkeys though. That's
still go.
Doesn't stop them.
No. But yeah, no, that's the only thing I saw, when I saw this, I was like, oh, maybe,
I mean, we can address
So we
that.
got,
But
no, we don't know the
Not
answer,
for-
we don't
No,
know
but I mean,
the correct
we can
angle.
address it
No.
and put something in for the driveway.
so we got the
Yeah.
road, we got the slope, we got the curb, then we got shoulder, but we don't.
But is that what you would basically state it as, is you only want the slope to be at some fraction of an inch per foot? Is that how we'd wanna
It's,
state that? That's typical,
Smooth transaction,
it's easier on the,
transition from.
that's up for
the purpose is
interpretation.
easier. Yeah,
Well,
when they break
yeah,
it
it
down
is,
into
but I mean,
percentage. you
It's
can
in
do it
there.
the same way.
Everything is gonna be,
Right. Versus a no greater than, oh, but what about down, like a downward pitch though too?
same thing.
Nothing greater than,
Yeah, because, assuming flow of traffic would be both ways, so you
Okay.
have the same.
wasn't sure if
Yeah,
it's.
no, that's right.
Okay, cool.
Any other motions?
Make a motion to adjourn?
I think that's fair enough.
Or a second?
I'll second that.
All in favor?
Aye.
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 8:29.